Good morning, everyone, and welcome to this last Fox Williams travel webinar of 2023. And the plan is today is that we're going to have a bit of a look forward session into 2024 to see what the main regulatory legal issues facing the travel industry are going to be in 2024. So the plan is that we're going to talk for about 45, 50 minutes, and then we'll have some time for questions at the end. You can post questions in the Q&A box, which you should be able to see on your Zoom window. And that we'll aim to guillotine so far as we can at 10 o'clock. This session is being recorded, although rest assured that nobody can see nor hear you. And we will circulate a copy of the recording and some slides after we finish. So what's on the agenda today? As I said, the sort of main legal developments which are going to affect the industry in 24. I'm going to talk about package travel reform. That's at the UK and the European level. Farina is going to talk about ATOL reform in the UK and also the Digital Services Act. And that's a landmark piece of European legislation which is going to affect people who trade online in a certain way. I'm going to look at the implications of the On the Beach Against Ryanair case, and then Lucy's going to look at the new regulatory enforcement powers which are coming along in the UK, as well as some other sort of quick-fire updates on some other things that are happening and might be of interest to the industry. Now, that's a lot to cram in about 45 to 50 minutes, but the aim of this session is really just to put things on your radar, to give you a bit of an introduction to what they are, so that you know what we consider to be some of the main things that you need to be looking out for next year. Next slide, please, Dan. And again. So package travel directive reform. Now, there have been some very recent developments here in that the European Commission has actually now published its proposed reforms to the package travel directive. These came out on Wednesday of last week. So we have read them and analysed them. So the plan is today to maybe spend a bit more time on this because it's so fresh. And then we'll spend a bit less time on the UK package travel reform. So in terms of the directive, obviously the first thing that some people might be wondering is this still relevant to you because of Brexit? And the answer is, well, it's going to be relevant to anybody selling to consumers in Europe, in the European Union. So no matter where you're based, whether you're UK-based, US-based, if you're based anywhere in the world, if you're targeting consumer sales in a member state, then these reforms to the package travel directive are going to be relevant to you because they change the nature of your obligations if you're organising packages or facilitating linked travel arrangements. Next slide, please. So why is this all happening? Well, it's really come about for a few reasons. The Commission generally reviews the status of directives that have been in force for a few years. And also here, we've had some fairly significant sort of economic shocks in the travel sector, which are referred to in the review documents by the European Commission as having particularly influenced some of the outcomes and some of the proposed changes. And they reference specifically the Thomas Cook failure, which was in 2019 and caused a huge sort of ripple within the travel industry, with unavailability of insolvency protection in many states, with cancellations of flights, cancellations of packages. So it provided a real insight into what parts of the PTD were working well and which parts weren't. And similarly, then obviously the COVID pandemic really stress tested the package travel directive, and that gave rise to some learnings as well and areas in which the Commission thinks the law could be improved. So in the preamble, in some of the documentation which accompanies the new text of the directive, the Commission really focuses in on three problems, three high-level problems that it saw with the directive, having carried out this review. One of which was, of course, refunds for cancelled packages. And the Commission just observed that, obviously, as we've seen in practice, compliance with a 14-day deadline to refund customers has just not been feasible at times of major disruption. And there's various reasons for that. And one of the reasons highlighted by the Commission was that often the package organizer doesn't have the liquidity to refund huge numbers of customers all in one go, particularly in circumstances where the customer money may have been used to pay for flights or to pay other suppliers, and that money hasn't come back. So that was one of the issues identified by the Commission. The scope of insolvency protection as well was another big issue. The Commission noted that in some member states, it was uncertain whether vouchers issued, instead of a refund, were protected by insolvency protection, and similarly, it was unclear in some member states whether refunds owed at the time of failure were covered by insolvency protection. Now, obviously, in the UK, we had the ATOL scheme come out, and we had these refunds credit notes, also for AMTA Bonds members as well. So the position in the UK might have been slightly clearer, but in other countries, its position wasn't clear. So the Commission wants to address that. And then similarly, and this captures a bunch of different aspects of the PTD. The Commission thinks that some parts of the PTD just aren't very clear, which has led to customer confusion and just inconsistent application of the directive in different member states. So the European Commission wants to address all of that. So next slide, please. So I'm going to run through what I see as these sort of key changes proposed by the Commission, and what's perhaps been one of the most controversial changes, and what I've read about, subsequently from various industry bodies as being an area of controversy, is this limitation on advance payments. So this is effectively mirroring what the position is in Germany at the moment, and the way that their consumer law works. But the idea is that package organisers will be limited in the deposits that they can take and the balance payments that they can take. So the proposal is that for bookings which occur more than 4 weeks before departure, the package organizer won't be allowed to take more than 25% of the total value of the package. And then the balance of the package can only be taken 4 weeks before departure. Now, obviously, if the customer books within 4 weeks, then the full amount of the holiday can be taken. But before 4 weeks, there are going to be these limitations. Now, that sort of position has been softened slightly by this exception, which got it here on the slides, which allows package organisers to take higher payments where that is necessary to cover the costs of organising and performing the package holiday. And it's specifically said to include situations where higher sum has to be paid to suppliers. So, for instance, just to illustrate that, if a customer books a package holiday and that package holiday includes a flight, and which is, let's say, 40% of the value of the package, and that 40% has to be paid in full by the organizer to the airline at the point of booking, then in that situation, I think what these reforms suggest is that the package organizer would be allowed to take 40% of the value of the booking, and not just 25%, because that's necessary to cover the costs of paying the supplier at the point of booking. I mean, it may obviously be higher if the supplier, if other suppliers also require full payment at the point of booking. So there is that caveat and that exception to the rule, but the main rule will be that there will be these two limitations to the amount of prepayments that package organisers can take. Next slide, please, Dan. So the other one, which is probably one of the most significant areas of reform, is around supply refunds, and um, this is looking at the right to redress provisions which are in the PTD. Now, those right to redress provisions are going to remain in force, but in addition to those, there's going to be an extra sort of clarification, which will which will require the travel suppliers to pay refunds to the package organisers within 7 days if those travel suppliers cancel or fail to provide one of the travel services. So obviously, perhaps one of the most obvious examples in this situation would be an airline cancels a flight. In that situation, the airline would have to refund the package organizer within 7 days. And the idea behind this is that the package organizer would then have the funds available to either rebook the customer or to refund the customer in full. So that's the position on that. Next slide, please, Dan. Um, Now, this next area is really a clarification of what insolvency protection must cover, and also how vouchers will be treated going forward. Now, in relation to insolvency protection generally, the reforms will require that any refunds owed at the point of failure will have to be covered by insolvency protection. So this will mean that if a package holiday is cancelled and the customer is owed a refund, then that refund, if the travel company then goes bust before paying that refund, then the customer will be able to go to the insolvency protection provider to get that refund back. And like I said, there was in some member states there was a lack of certainty about whether that was covered under their insolvency protection arrangements. But this is just to put it beyond doubt that it will be covered. Now, vouchers. I mean, this is obviously really a pandemic issue and something that the Commission wants to address from two different perspectives, really, from a general sort of consumer perspective, and then also a insolvency protection perspective. So, firstly, the Commission wants to kind of regulate the use of vouchers a bit better. I mean, arguably, the customer already had these rights under general consumer protection law, but the Commission wants to make it clear that if you offer a voucher for a cancelled package, then that must be as a genuine alternative option to a cash refund. So the package organizer will have to give the customer a genuine choice between a cash refund and a voucher, and then it's up to the customer to decide. There's going to be a maximum term for these vouchers, and that's going to be 12 months. That 12 months is then extendable by a further 12 months, but that has to be with the explicit written consent of the customer. So it's not something that can be kind of unilaterally extended by the package organizer. And then at the expiry of the voucher, if the voucher isn't used, the customer must be paid cash for the value of the unredeemed voucher. And then, like I said, on insolvency protection, these vouchers must be covered by insolvency protection so that if the travel company fails, the customer can get the value of the voucher from the provider of insolvency protection. And then lastly, quite an interesting one, these vouchers must be transferable from one traveller to another. So I suspect one of the issues here is going to be concerns around, creating secondary markets for vouchers. So that's not been mentioned in any of the proposals, but I suspect it will be something which we'll come back to as the proposals pass through the legislative machinery at the European level. Next slide, please. Now, this is possibly one of the most low-key but significant changes to the Package Travel Directive. I say low-key because, from what I've read, other commentators have focused on other things within the reforms, but this seemed to me to be potentially quite significant as well. So the Commission is going to expand the definition of what is a package. If you remember, at the moment, there are 6 different definitions for what is a package, like 6 different arrangements which fall within a package definition. And the Commission is going to extend that quite significantly. Effectively, any website or retail store where it's possible to buy 2 different travel services, even if those are booked in completely separate transactions, will be capable of being a package. And that's even if they're not bundled together in your classic sort of shopping basket model. It'll still be a package. So there's 2 specific scenarios we're sort of talking about here, which have been inserted into the package definition. And the first one is a situation where a customer goes to a shop or a website, books a travel service, let's say a flight, leaves, comes back 3 hours later to that same website or store to book something else, let's say a hotel for the same trip. Now, that's going to be a package under these new proposals. So that's going to catch a significant number of business models which are currently outside of the definition of a package. So any situation where a website may have different tabs for different travel services, where they don't allow the customer to bundle those different travel services together, it will, if this definition goes through, it'll be possible for that model to lead to the creation of a package, which is quite significant, I think. The other one, the other scenario is similar to that first scenario, exactly the same as that first scenario, except that the customer returns within 24 hours to book that second travel service. Now, this will lead to the creation of a package, provided that the travel company offered or invited the customer to book another travel service before they purchased the first travel service. So this obviously anticipates some kind of targeted marketing towards the customer whilst they're going through the booking process for the first travel service. If that happens, and if the customer comes back within 24 hours to buy a second travel service, then that's going to be a package. So again, that seems quite a significant extension of the PTD to me, and something which obviously operationally is going to be quite difficult to track and monitor for travel companies. So just very quickly, I already gone over my time, but very quickly, I'll just mention that as a consequence of these changes, one of the linked travel arrangement definition is going to be deleted, and that's the first kind of linked travel arrangement where it's possible for the customer to make 2 separate transactions with a single retailer, and that creates an LTA. So that's going to be deleted. The one other thing to say, which I thought was quite significant as well, is that the existing category 5 of a package, that's the click-through package, is going to be modified so that at the moment, for a click-through package to be formed, it's necessary for the first travel company to pass through the customer's name, email address, and payment details to the second company. Now, under these modifications, one of those in itself will be sufficient, or alternatively, other personal data. So if any information is basically passed from the first trader to the second trader, then that could lead to the creation of a click-through package. Next slide, please. I was going to mention this very, very quickly. Customer cancellation rights, these are going to be extended effectively. So the right of the customer to cancel and get a full refund where there are unavoidable and extraordinary circumstances. During the pandemic, we saw that there were actually limitations to these rights because the unavoidable and extraordinary circumstances had to happen at the place of the destination. And it wasn't strictly necessary what was happening at the place of departure. So this is going to be changed. So effectively, wherever the unavoidable and extraordinary circumstances occur, if they significantly affect the package, then the customer will have a right to a full refund. A couple of other things as well on this were quite interesting. So there were calls to give the customer automatic refund rights whenever official travel advice is not to travel to a particular destination. So that would be somebody like the FCDO advising against travel. The commission's decided not to go with that and just to effectively maintain the status quo, where they say that this official travel advice will be an important element to consider whether there are unavoidable and extraordinary circumstances, but it won't in itself give the customer an automatic right to a refund. And there's a similar comment in relation to quarantine. So if there are serious restrictions imposed on the customer, whether that's at the place of destination or after returning home, then in itself that doesn't trigger full refund rights, but it will be an important element to take into account to see whether there are unavoidable and extraordinary circumstances. I think the Commission said they think it's important to just maintain a case-by-case assessment on this particular issue. Next slide, please. I'll just mention this quickly as well, because it is potentially quite significant. But this isn't a change to the Package Travel Directive. It's a change to Regulation 261, which is happening at the same time, because the Commission is also reforming the passenger rights regulations at the same time. And the part of this I found interesting was that this concept of intermediaries will now be introduced to Regulation 261, and whenever an intermediary books a customer flight with an airline, the intermediary will be required to give the customer's contact and booking details to the airline, which the airline can then use for regulatory purposes only to satisfy their regulatory obligations. And the other thing is that the intermediary will have to tell the airline at the point of booking that it's booked the ticket as an intermediary. And the intermediary will also have to give its own postal and email address to the airline. But the quid pro quo there is that the intermediary will be entitled to ask to be copied in on customer correspondence, so that if the intermediary is acting as a package organizer, then the intermediary will be able to have the information that it needs to comply with its regulatory obligations. So next slide, I think that's it. Yeah, just to say, these proposals have been published by the Commission. They're now, going to go through the legislative machinery of the European Union. So, further changes are possible as it passes back and forth between the European Parliament and the European Council before the text is finally settled. Even when it is finally published as a directive, there will then be a period of time for member states to bring it into force. Usually something like 18 months. sorry, there'll be 18 months for it to implement the directive into its national law, and then there's usually a further period of time, let's say 6 months, before that then comes into force. So these changes actually becoming reality are still a way off, but you know, the proposals have now been published, and I'd be surprised if there were any radical changes to what's been suggested. So that's it on the PTD. If I can have the next slide, please. And again, just to say, this is just 2 minutes on this, because it's not the most topical issue because it's been with us for a while. But obviously, the UK is looking to reform the package travel regulations at the same time. Obviously, now post Brexit, completely separate to what's going on at the European level. The Department for Business and Trade published a call for evidence, which identified various areas that they're looking at and that they would be interested to know what people think. That call for evidence closes on the 13th of December, and they're looking at things like supplier refunds, whether there should be any sort of relaxation of the rules in extenuating circumstances like another pandemic, whether domestic packages ought to be taken out of the regulations, and then more flexibility on insolvency protection for non-flight packages, as well as what I would call some other bits and pieces which might not be that substantial. So I'm gonna stop there, because I've already gone over my time, and hand over to Farina to talk about ATOL reform.
Thanks, Rhys. So yes, continuing with the theme of reform, I'm going to give a very brief update on ATOL reform. If we could just move on to the next slide. Thanks, Dan. So back in 2021, the CAA started a consultation on ATOL reform. It was after some high-profile collapses such as Thomas Cook and Monarch, as well as the COVID-19 pandemic, and the CAA felt that the industry needs to build more financial resilience and to better protect customer monies. So the consultation proposed a range of changes on how ATOL holders fund their operations, how customer monies should be used, and how the ATOL protection contribution, the APC, should be calculated. So since the initial consultation back in 2021, there was a further call for evidence from the CAA at the beginning of this year. We're currently waiting for a further and likely to be final consultation on the detailed proposals being put forward by the CAA. However, you might have seen in the press recently that the CAA has confirmed that the further consultation has been delayed. We were meant to have it in the autumn of this year, but now it's looking likely to be released at some point next year. So I'm just going to look briefly at the proposals for ATOL reform, and in particular what we learned from the call for evidence earlier this year. So looking at the CAA's commentary in the call for evidence, it's quite clear that mandatory segregation of client money is the CAA's preferred option. So this means that customer payments would be segregated from the ATOL holder's working capital, and cannot be used by the ATOL holder until the monies are released from segregation. So the options being put forward for segregation of customer monies is our total trust segregation. So this is where all customer monies remain in trust until the successful completion of the holiday. There's also the option of partial trust segregation. So this allows for the early release of limited funds to pay suppliers. So, for example, a set percentage of the customer monies could be released to pay certain suppliers, like airlines, for example. And another option is trust segregation that allows for the early release of all funds, but only to pay suppliers of the package holiday. And to support the financial protection of the early release of monies, this would be underpinned by mechanisms such as bonding or financial failure insurance. So that would then ensure that any customer monies that have been released early would remain financially protected. And then the last option being put forward by the CAA is client account segregation. So this is where a designated company director would take responsibility of the client account, which would operate under any of the approaches that I've just mentioned. And then the operation of the client account would be validated on a certain frequency by an independent auditor, which would likely be an ATOL reporting accountant. So they are the options there for segregation. And as I mentioned, it looks like segregation is the preferred option as opposed to bonding or financial failure. But bonding and financial failure are options that could be used alongside segregation of client monies in order to sort of underpin where there's early release of customer monies. So moving on to variable APC. Sorry, just back one slide. Sorry, Dan. Just going to talk briefly about APC before I move on. So at the moment, APC, which is the ATOL protection contribution, is currently a flat rate of £2.50 per person per booking. So the CAA is consulting on bringing in a variable rate APC. So the APC would then vary depending on the size of the ATOL holder, the average value of the trips, and the financial strength of the ATOL holder. So essentially, it would be a risk and value-based calculation. If a company was to fully segregate their customer monies until completion of the holiday, that would give them a lower risk profile, and they could then potentially pay a lower amount of APC as a result. And the range of sort of APC could be anything from sort of 50p to £15, depending on sort of the value and the risk profile of each ATOL holder. The responses to variable APC from the industry was that the industry generally supports the idea of having this variable APC. So it looks like this is likely to come into play, but we will find out hopefully at some point. I would imagine in the early part of next year when we do get the final consultation. So that brings me to the end of a very brief overview of ATOL reform. So I'll now move on to the Digital Services Act. Thanks, Dan. So I'm just going to provide a very brief overview of the DSA, who it applies to, and its key obligations, with a focus on how it may impact the travel industry. So as Rhys mentioned, we think this is going to be quite significant for the travel industry, and it contains new rules for online intermediary service providers, where they provide services to businesses and consumers established or resident in the EU, and the rules would apply irrespective of where the service provider is established. And the services in scope include search engines, social media platforms, and online marketplaces. So the DSA came into force on the 16th of November 2022, but with the majority of its provisions applying to service providers from the 17th of February 2024. However, this year, by the 17th of February 2023, all online platforms were required to publish information about their average active service recipients, so service recipients being the users of the platform. And this was to enable the European Commission to establish which service providers should be designated very large online platforms and very large online search engines, as a higher level of regulation applies to those service providers. So the DSA applies to intermediary services, and an intermediary service is either a mere conduit, a caching service, or a hosting service. So if we move on to the next slide, I will go through the definitions. So the intermediary service is essentially the umbrella term for all of those services within the scope of the DSA, and they're then broken down into these separate definitions. So a mere conduit is the transmission in a communication network of information provided by a service recipient, so a user, or the provision of access to a communication network. In other words, a service provider which acts as a pipeline for transmitting information sent by users, or which gives access to that user to the pipeline. Examples given by the DSA include internet exchange points, Wi-Fi boxes, virtual private networks, and domain registries and registrars. A caching service is a transmission and a communication network of information provided by a service recipient involving the automatic, intermediate, and temporary storage of that information for the sole purpose of making more efficient the information's onward transmission to other recipients upon their request. So the most obvious example here is that of internet service providers applying caching technology by storing previously delivered web pages temporarily on their servers in order to speed up the delivery of those web pages to web users. So a hosting service is the storage of information provided by and at the request of a service recipient. In other words, a service provider provides space for users to store their content. And providers of hosting services have additional obligations which are not shared by providers of mere conduit and caching services. An online platform is a subcategory of hosting services. It's a hosting service that, at the request of a service recipient, stores and disseminates information to the public. And the DSA gives examples of social media platforms and online consumer marketplaces. And it's this definition that we think could apply to certain booking platforms in the travel industry. An analysis would have to take place to see whether your business falls within the definition of an online platform. And that would include analysing the type of service being provided by the travel business and the amount of control that the travel business has over the content that it's displaying. So next slide, please. So looking at the key obligations that the DSA imposes. So the requirements that the DSA imposes increase cumulatively depending on the breadth of the provider's activities. So mere conduit and caching service providers have the fewest obligations, and there are then additional obligations which apply to providers of hosting services and online platforms. So looking briefly at the obligations on all intermediary service providers. So they must designate a single point of contact to enable direct and rapid communication by electronic means with member states authorities, with the European Commission, and with the Digital Services Board. And the Digital Services Board is a board that's being set up by the European Commission for the purposes of the DSA. And the Digital Services Board will then have oversight over how the DSA is being implemented and enforced by member states. The intermediary service providers must designate a single point of contact to enable the users of the service to communicate directly and rapidly with the service provider by electronic means and in a user-friendly manner. Service providers that are not established in an EU member state, but they offer services in the EU, must designate in writing a legal or natural person as their legal representative in an EU member state where they offer services. And that legal representative must have the powers and resources to cooperate with the relevant authorities, with the European Commission and with the Digital Services Board, and be able to comply with any decisions made by them. So examples of an appropriate legal representative would be an EU-based subsidiary in the same group as a service provider, or the service provider's EU-based parent company. There are certain obligations around terms and conditions and what information must be included in those T's and C's. So if the service provider imposes any restrictions on the use of their service in respect of information which is provided by the users, they must include information on those restrictions in their terms and conditions. And that information must include information on any policies, procedures, measures and tools which are being used for the purpose of content moderation, including algorithmic decision making and human review, and the rules of procedure of their internal complaint handling system. And then lastly, all service providers must at least annually publish reports on any content moderation that they have engaged in. And that should include information on how many orders the service provider has received from member states in relation to illegal content, details of its own content moderation activity, the number of complaints that it's received through its internal complaint handling system, and any use that's been made of automated means for the purpose of content moderation. Next slide, please, Dan. And then, as I mentioned, there are some additional obligations on providers of hosting services, and this includes online platforms. So firstly, there are some additional transparency obligations. So hosting service providers must provide some additional information in their annual reports, which includes how many notices of illegal content they have received, and in relation to complaints received through the internal complaint handling system, what decisions were taken in respect of those complaints. Hosting service providers must also provide easy to access, user-friendly mechanisms which allow any individual or entity to notify them of illegal content, including by electronic means. If a hosting service provider restricts information provided by a user on the grounds that the information is illegal content or is incompatible with its terms and conditions, it must give the user a statement of reasons explaining why it has done so. And I've included the definition of illegal content on the slide there as well. And essentially, it's any information that in itself or in relation to an activity, including the sale of products or the provision of services, is not in compliance with union law or the law of any member state. So when we refer to illegal content under the DSA, that is the definition, and that's what we mean. And the last point to just mention there is if a hosting services provider becomes aware of any information giving rise to a suspicion that a criminal offence involving a threat to human life or safety has taken place or is likely to take place, they must promptly inform law enforcement or judicial authorities of the member state concerned and provide all relevant information. So next slide, please, Dan. So looking at the additional obligations on online platforms. So again, there is some additional transparency obligations, so additional information which needs to be included in the annual report. Online platforms must also have an effective internal complaint handling system. And the purpose of that system is to give users the ability to object to decisions that have been taken by the platform in relation to user content being illegal or incompatible with the platform's terms and conditions. The platform must also provide some form of external dispute settlement, so some form of an alternative dispute resolution body which allows internal complaint decisions to be reviewed by this external body. There's also this concept of trusted flagger, which has been created by the DSA, which is basically an independent body or person with relevant experience in detecting, identifying and notifying about illegal content. And they submit notices diligently, accurately and objectively. And so platforms must use technical and organisational measures to ensure that notices submitted by trusted flaggers are given priority and are dealt with as a matter of priority. So if a platform has a user which frequently provides illegal content or frequently submits notices or complaints that are unfounded, the platform must issue a prior warning and then suspend access to their services for a reasonable period of time. So essentially the platform is under an obligation to take some action in those circumstances. And platforms must not design, organise or operate their online interfaces in a way that deceives or manipulates users or materially distorts or impairs the ability of users to make free and informed decisions. So we think this is quite an interesting element of the DSA. And it does provide some examples of the types of behaviours that it's referring to here, which within the DSA is referred to as dark patterns. And it includes presenting choices in a non-neutral manner, repeatedly requesting a user to make a choice where they've already made that choice. For example, where a customer has chosen not to purchase an additional service on the platform, but the platform keeps coming up with a pop-up or keeps asking the user whether they want to add it on, that would be considered a dark pattern under the DSA. Other examples are making the procedure of cancelling a service significantly more cumbersome than it was to sign up to the service, and making it unreasonably difficult to discontinue purchases or to sign out from an online platform. So there's some of the examples there that the DSA has given in their recitals. Online platforms that display advertisements on their online interfaces must ensure that users can identify in a clear and unambiguous manner and in real time that the information displayed is an advertisement, on whose behalf the advertisement is presented, and if different, who's paid for the advertisement, and meaningful information about the main parameters used to determine the recipient to whom the advertisement is presented, and where applicable, how the user can change those parameters. And online platform providers cannot target advertisements at users based on profiling, which uses special categories of personal data. And that's the same definition as the GDPR when it comes to special categories of personal data. So additional rules there for online platforms that display advertisements that will significantly impact how those advertisements can be displayed on the platform. And then the last point to just mention on here is a recommender system. A recommender system is an automated system used by a platform to suggest or prioritize specific information, including in search results, or which otherwise determines the relative order or prominence of information displayed. So where a platform uses a recommender system, there's certain information it must include in its terms and conditions around the main parameters that it uses in that recommender system, and it should explain why this certain information is displayed in the way that it is, and why it's being suggested to that particular user. So just on the last, moving on to the last slide, please, Dan, and very quickly, because I am conscious of time, just to sort of complete this, there are further obligations on online consumer marketplaces. So if you're an online consumer marketplace, you must obtain certain information from the traders that are using your marketplace to sell services before permitting them to use the platform. And that information is name, address, telephone number, email address, identification documents, payment account details, and a self-certification from the trader, which states that it would only provide products and services which comply with EU laws. So these are certain obligations being placed on the platform around being able to trace and verify the traders that use that platform. And providers of online consumer marketplaces must also ensure that their online interface is designed and organized in a way that enables traders to comply with their obligations regarding pre-contractual information, compliance, and product safety information under the applicable EU law. And then the last point is that online consumer marketplaces that become aware that an illegal product or service has been offered through their platform to EU consumers must inform the consumers who purchase the illegal product or service from the marketplace that that product is illegal, that product or service is illegal, of the identity of the trader and of any relevant means of redress that are available to that consumer. So quite a significant obligation there being placed on an online consumer marketplace. So that brings me to the end of my section on the DSA. I will hand back to Rhys.
Thanks very much. I'll try to canter through this. We are going to run past 10 o'clock, but I'll try and go quickly. So this is obviously the On the Beach and Ryanair case, which was all to do with refunds. And it's been in the press recently because the judgment has just been handed down by the High Court. And it's obviously quite significant because it's the first case dealing with rights of address under the package travel regulations. I mean, the background to the case is very straightforward. I mean, obviously, the COVID pandemic caused the mass cancellations of flights and also changes to flights, particularly in the first 3 months or so in the UK where pretty much all flights were grounded, other than some special flights that did operate. And then naturally, that then inevitably caused the package holidays, which included those flights, to be cancelled. OTB in this case refunded the customer in full, in cash, including the flight, as was required by the PTRs. At the same time, Ryanair offered a refund to the customer, which OTB accepted on behalf of the customer, but then Ryanair didn't pay that refund. So that's what gave rise to the claim, and ultimately OTB was trying to get back that refund element from Ryanair. Next slide, please, Dan. So in terms of the legal issues coming out of this case, OTB relied upon two legal bases to bring its claim. The first one was this right of redress under Regulation 29 of the package travel regulations. And this basically provides an organizer with a right of redress against a third party in situations where the organizer incurs a loss complying with its obligations under the PTRs, for instance, paying a refund, and some third party contributed to the event which triggered that loss. So here, obviously OTB had to refund customers under the PTRs, so it suffered that loss. And the event which caused that was the cancellation of the flight, and Ryanair at least contributed to that because it was the operator which cancelled the flight. So this was the first ever case under Regulation 29, and it was defended by Ryanair partly on the basis that it said that Regulation 29 doesn't of itself create a freestanding legal right of redress for an organizer. It just preserves any rights that they may have otherwise. For instance, if there's a contract in place, then Regulation 29 would just seek to preserve any of those rights, as opposed to create any new rights. And obviously what On the Beach was saying was, no, Regulation 29 creates a freestanding legal right of redress for package organisers against airlines. And the High Court agreed with On the Beach on that point, and it traversed the directive which sits behind the regulation. It looked at what the European Parliament had to say about the relevant provision and the intention behind what they were seeking to achieve when they drafted the package travel directive. And the judge in this case came to the conclusion that Regulation 29 does create a freestanding legal right. Therefore, On the Beach won on that basis. Next slide, please, Dan. But On the Beach also brought its claim on a second legal basis, which is quite interesting because it's actually quite it's a quite broad application, potentially beyond just package organisers. So on the Beach brought a claim in the alternative on the principles of unjust enrichment, and this is a common law legal principle basically, and it provides for certain legal rights in this situation. So if you have two parties, A and B, both have a legal obligation to refund the customer. If A then pays that refund, and in doing that discharges B's obligation to pay the refund, then B is obviously enriched in that situation because B doesn't have to pay the refund anymore. And if there are circumstances which means that that's unjust, perhaps because B is ultimately responsible for the loss, then these principles of unjust enrichment allow A then to get a contribution or a payment from B in order to make everything fair and just. So in this case, OTB relied upon this legal principle, and it said that, look, both OTB and Ryanair owed a refund to refund the customer. OTB had cancelled the package, therefore it owed an obligation to refund the customer. And from Ryanair's perspective, it cancelled the flights, it offered the refunds, the customer accepted that, therefore it should have to, it has an obligation to pay that refund. So we on the beach in that situation paid the refund, and it argued that, well, it's unjust for Ryanair not to have to pay any refund, and the court agreed and said that yes, Ryanair has been unjustly enriched, and therefore it should compensate OTB for that by paying refunds for the flights to OTB. Now, what was interesting about sorry, next slide, please, Dan, before I go into the wider implications. I mean, what's interesting about all of this is it obviously adds a bit of legal clarity on the refund situation between suppliers where they cancel or make changes to flights and organisers. Regulation 29, has been clarified by the High Court that it does create this freestanding legal right of redress, and that's even in situations where there's no contract between the organiser and the airline. And then on the unjust enrichment principles, that's a principle whereas Regulation 29 can only be relied on by package organisers. Actually, the principles of unjust enrichment are broader than that, and it might on a particular case, it might be possible for other travel companies which aren't package organisers to rely upon unjust enrichment. What needs to be, like I said earlier, what needs to be showed is that both the organiser and the airline both owe obligations to refund the customer, and one of them pays and the other one's enriched. So I had better move on, but I just say this. It is, there are obviously other companies out there with refunds claims, some of which go back 6 years, which is the relevant limitation period for claims like this. So it may be that obviously other companies will now want to bring their own claims for refunds for flights that they had to refund to customers during the pandemic, where they still haven't had back the refund from the airline. So I say watch this space on that to see whether we get more claims like this in 2024. So that's it. I'm just going to hand over to Lucy to deal with the new regulatory enforcement powers.
Thanks, Rhys. Yes, I'll very quickly do this. I can canter through it. So this is just a reminder of something we covered back in the summer. UK consumer law is under the spotlight because it has not historically been complied with as well as it could have been, let's say generally, but specifically in the travel industry. Just by way of reminder, sort of consumer law is two levels. There's general consumer law and travel consumer law, basically package travel regs, which deal with very specific things. And then general consumer law is sort of fairness, marketing practice, how companies generally sell to consumers. Next slide, please, Dan. And there is a new bill currently working its way through Parliament, which is aiming to put breaches of consumer law on the same pegging as breaches of data protection legislation or competition law. Next slide, please, Dan. The Act or the bill is the Digital Markets Competition and Consumers Bill. It originally came out, was published in April this year, and a week or so ago it entered the House of Lords. It's been through the House of Commons. You'll see on the slide there where it's currently at. And today is the debate, good timing for a full review of the entire bill. Next slide, please, Dan. It's sort of in three parts, and it's the third part which is just the focus of this. The first two parts, digital markets and competition, it's all about behaviour of the big tech firms and trying to squash dominant anti-competitive behaviour. But the third and fourth parts are about consumer law and consumer law enforcement in particular. And the bill is very likely to come into force next year, and probably with a bit less lead-in time than some of the EU legislation that we see. Next slide, please, Dan. So just by way of reminder, existing enforcement powers pretty much a bit toothless. Competition and Markets Authority have some powers, but they're not very strong, let's say. Next slide, please, Dan. And so the new enforcement powers are basically giving a lot more power to the Competition and Markets Authority. It will be able to decide whether a travel company has breached consumer law. So it will hold all the cards and decide whether there has been a breach, and then take action to enforce remedy of that breach. And it can decide what sanctions are imposed, and whether this is the sort of rockets that they want everybody to listen to, the fines that they could charge travel companies for non-compliance, and it will be up to the travel company to appeal to court. So currently CMA has to go to court to get at compliance. Now the shoe will be on the other foot, that the travel company will have to defend itself. Next slide, please. And just by way of reminder, the fine is on group turnover. So it's potentially, again, GDPR equivalent, up to 10% of group turnover. So if holiday company is just one of a group, say in the middle on the left there, it's not just the 10 million turnover, it's parent co and subsidiaries, which will all factor into the calculation. So potentially big fines. Next slide, please. I'll skip past that, actually. There's a new process. Undertakings will still be a thing. Again, we'll have a bit more power and a bit more teeth. So the CMA will look for undertakings from companies, and if they're not complied with, it's more that they can issue undertaking enforcement notices, which have more teeth than now. They have to take travel companies to court for non-compliance with undertakings, and fines could be issued for non-compliance with undertakings as well. So again, more remedies available to the CMA. Next slide, please. I'll skip past these slides and just move on, keep going to other important matters. I think just to flag again that individuals could be up for infringement notices if they've knowingly or been involved in the non-compliance of consumer law, and other regulators may have a bit more power as well coming down the tracks. So moving swiftly on to just a couple of other things that to be aware of next year. In March, there is a deadline for UK companies who transfer personal data outside the UK and the EU to include the International Data Transfer Agreement into their contracts. This is, if you are familiar with the EU SCCs, that's the equivalent of the UK SCCs, and there is now a deadline for companies to include those in contracts. So start reviewing your contracts if you haven't already. PSD3, not PTD, payment services. There is a proposal at the EU level to evolve PSD2. So this is what brought in strong customer authentication and a lot around open banking, but there's a big impact for travel companies. The current suggestion is the one change which business travel companies can benefit from. That exemption may be removed. It's all under discussion at the moment, so there's nothing concrete yet, but that's something to watch out for next year. And the last two, very conscious of time, short-term rentals. There is, again, draft regulation working its way through the EU powerhouses on sharing data, basically making platforms that offer short-term rental accommodation more responsible for who is on their platform for the accommodation, and there'll be an obligation to share data and information so that the hosts basically can be contacted. This all leads into, I think, VAT payments and tax payments that the EU think are not being paid as well. And then lastly, in the UK, there is a consultation that finished earlier this year about interest-free buy now, pay later products. Again, it's just being considered by UK government. Whether it gets paused because of elections next year, we'll see. But that's, again, something to watch out for next year. There we go. 4 minutes over.
Thanks, Lucy. I think you almost brought us back on track. So that's it. Thanks very much, everybody, for joining. So we will circulate a copy of the recording and also the slides to everyone who joined. And if anyone else wants to reach out and ask any specific questions, then please do so, and we'll aim to deal with those. So thanks very much.